and grievance. And if you were recording, if you don't want it recorded, I think you have to blur yourself or something. What is the rule for that? I don't know.
Turn your video off.
Turn your video off. And I think there's actually, it comes up on your screen. So anyway, we do record it because a lot of people who aren't able to attend, it becomes a pretty good resource. Okay, we did 5 of these already, and we're going to do 6. We have one more coming up in September. That's going to be on medical issues in the department. We at Restore Justice have partnered with Uptown People's Law Center. At Restore Justice, we work on state-level policy reforms that impact people serving extreme prison sentences and their families, with an emphasis on youth and emerging adults. Do you want me to read Uptown's, Alan, or do you want to?
Oh man, can't read it. People read it for themselves.
Oh, okay. But let's just say,
we've been around for a long time. We don't do policy work at all. We sue the prison system on behalf of prisoners. We also do tenants' rights, and we also do some Social Security disability work.
For over 40 years.
Yes.
For our housekeeping, we're going to get our intros, which is really Alan. And I'm going to ask everyone, we'll just skip to the next and go right to housekeeping, which is if you can go on mute just because of background noise. And if you have questions, if you put them in the chat, we have several staff members from Restore Justice here who are going to monitor the chat. And when they feel like Alan has a pause or there's a good time, they will be asking your questions. So we will get to all of your questions. Here's Alan, and I just have to say, he's been at Uptown People's Law Center since 1979. He served as a staff attorney for 2 years and became legal director in 1992. 2014, he became the executive director. Under his leadership, Uptown has developed the largest docket in the state of Illinois of civil rights cases filed on behalf of Illinois prisoners. Uptown currently has, is it still 5, or did you get some settled, I thought?
Nope, it's 5.
Pending class action suits protecting Illinois prisoners' civil rights.
But 2 more on the way, so 5 for now.
2 more on the way, I love it.
Stay tuned.
And we're ready for Alan. See, that was pretty quick and painless.
There you go. Okay, so you can go to the next slide. So the obvious question is, why do we care about grievances? In a good system, and I emphasize the word good, which I'm not suggesting Illinois is one, grievances are really important. Grievances are a way for prison officials to identify problems, and a way that they can then identify whether it be a problem part of the prison, whether it be a problem staff member, whether it be a problem with food, whatever it is. It gives the management a chance to know what's really going on from the prisoner's perspective and act on things and fix it. The problem is Illinois doesn't use them that way. Illinois doesn't have a computerized system, so it can't even tell you if there is, for example, a guard who has lots and lots of complaints against them. For example, with the Chicago Police Department, they do keep those records, and we now know that a very small percentage of the Chicago police officers have the vast majority of use of force complaints against them. The Department of Corrections could not tell you that about correctional officers because it doesn't track them. And the problem is that this wonderful law called the Prison Litigation Reform Act, which is really the Prison Litigation Suppression Act, gives prison officials an incentive not to have a good grievance system. What the act says is that if you don't exhaust all your administrative remedies, then you can't ever file a lawsuit in federal court. So it has made it so that prison officials have an incentive to make the grievance system as complicated and as non-responsive as possible in order to dissuade people from finishing the system. Because if they don't finish the grievance system, they can never go to court. So what exactly does the act say? It says, and it's on the screen, but I'm going to read it anyway. No action shall be brought with respect to prison conditions under 1983 or any other federal law by a prisoner until such administrative remedies as are available are exhausted. Now, the reason I put some of those words in highlighted is because each of those means something. So let's go through them one at a time. Julie? No action shall be brought. That means that you have to exhaust the administrative review process or the grievance process before the lawsuit is filed. The fact that you get turned down the day after your lawsuit is filed doesn't matter. Your case would still be dismissed. So you have to go through that whole process, and we'll talk in a minute about what the whole process looks like in Illinois. But you have to go through that whole process before you file. The second thing is respect to prison conditions. For a while, there was a lot of argument of what that meant. So, for example, if you got beat up by a guard, it doesn't sound like it's a prison condition. It sounds like I got beat up by a guard. But many years ago, the Supreme Court decided that prison conditions meant anything that happened inside a prison. So being beat up by a guard is a prison condition, being too cold is a prison condition, being held too long in prison is a prison condition. So it really means anything that happens inside a prison is a prison condition. Next slide. By a prisoner. Well, that's important too, because it means it's someone who is currently incarcerated. That is incarcerated on the day that they file the complaint. So for example, if something happens to you in prison and you're getting near the time you're going to be released, we always tell people wait till you get out, because then you avoid all this entirely. If you're going to get out in 6 months, there's no reason to file a lawsuit now. You should wait until you're out in 6 months and then file the lawsuit. Then you don't have to worry about exhausting the grievance process. And there's several other parts of this act which you also don't have to worry about. But we're talking about grievances today. So it means if you're in a prison, it also applies to some other facilities that look like prisons. It certainly applies to jails. It applies to halfway houses. It applies to work release if you're required to be somewhere at night. So basically, it covers anything that you are stuck in, any geographic place that you're stuck in as a result of being convicted or for juveniles adjudicated delinquent for a violation of criminal law or for violating parole or probation or any sort of diversionary program. If you're in mental health lockup because you were diverted from the criminal system, you're still considered a prisoner. So all those things are prisoners. It's a very broad definition. Go ahead. As are available. That means that you have to use the forms that are designated by the prison. You have to use the times that are designated by the prison. You have to use the specificity required by the prison. So, for example, in Illinois, you're required to identify who the staff member is you're fighting against. If you don't know their name, you're supposed to give a description and the shift or assignment that they had at the time they did something wrong. If you don't complete the process in accordance with the law, then your federal claims may be barred forever, regardless of how meritorious they are. So you can have a great case, but if you screw up one of these requirements, if you screw up one of the procedural requirements for a grievance, like you file it a day too late, they can deny it based on the fact you filed it too late, and then you are out forever and you can never again bring a claim. On the other hand, go back one more, I wasn't finished. As are available also means that the prison has to actually have a grievance system and it has to be available to prisoners. So for example, if they refuse to give you a grievance form, then it's not available to you. If they never answer a grievance, then it's not available because it doesn't give an answer. If it can't give you an answer within a time frame that makes sense, like you have a serious medical condition which needs to be dealt with like tomorrow, and the grievance system, you file a grievance, you wait 6 months and nothing happens, then it's not available. And what often happens is grievances just disappear. We'll talk a little more about that in the future, but basically the courts have said, if you as a prisoner do what you're supposed to do, the fact that the prison doesn't do what it's supposed to do doesn't bar you from bringing a case. So lots and lots of the actual fighting about the grievance process is based on this question of whether or not the grievance system is actually really available. That is it capable of giving an answer? Now, that does not mean that it's going to give you the answer you want. So it doesn't matter if 50 other prisoners filed a grievance about the exact same thing and they all lost. You're prisoner number 51, you have to go through the motions anyway. So even if you know you're going to lose the grievance, then you have to go through it. And that's one of the reasons, again, why the prison system has such an incentive to make sure that the process doesn't work. Because if people know that it's useless, lots of prisoners won't bother to file a grievance, saying, well, there's no point, I never win them anyway. Well, that's true. You're not going to win very many grievances in the system. But if you don't try, and if you don't go through the whole process, you may never be able to go to federal court at all. The other big part where this comes up is language barriers. There was a recent case won by my friend Sarah Grady in the Seventh Circuit, which she represented a prisoner who only spoke Spanish, and the grievance forms were only available in English. And the instructions for filling them out were only available in English, and none of the guards in that particular facility spoke Spanish. So he didn't file a grievance because he had no idea how to do that. And the court said, yes, if in fact this person only speaks Spanish and they're not given any assistance in Spanish, then the system is not available to them. This also comes up with blind prisoners. There are a few in Illinois that are blind, and anybody else who doesn't have the capacity to do it. There was a case litigated by somebody who was hit so hard that he went into a coma, and therefore he didn't file a grievance, obviously. And the Department of Corrections said, well, you didn't exhaust your administrative remedies. I'm like, well, the answer is I was in a coma, so there were no grievance process available to me because I was not capable of doing that. Same with people who are very seriously mentally ill. If you're, for example, suffering from schizophrenia and you're not quite in touch with reality, and you're not getting treated, you may well not be capable of filling out the grievance forms, and you may not be able to get the kind of help you need. Similarly, people who have a really low literacy level may not be able to navigate the rules and fill out the grievance forms properly. So there are lots of exceptions, and that's where a lot of the fight comes down to. A Department of Corrections saying, well, of course this grievance system is available, and prisoners saying it isn't. So whether it's not, it really is available is a big deal. One more. And the final requirement is that they have to be exhausted. Now that means you have to go all the way through to the very highest level within the prison system and get a final ruling. Again, if they just don't ever give you a final ruling, they can't avoid being sued. It'd be a great way to avoid being sued if you're a prison official. Just say, well, I'm never going to answer any grievances. Then I'll never get sued. Well, they can't do that. However, Illinois, unlike, for example, the federal system, doesn't have any deadlines by which you have to answer. So in the federal system, if you file a grievance, you don't get a response within 60 days, then it's deemed denied and you can appeal to the next level. Illinois has no such timelines. It says they should respond within the 60 days unless there's a good reason not to. That's not quite the exact language, but essentially that's what it says. So we did a case where somebody filed a grievance, didn't get a response. We filed lawsuit after waiting, probably 3-4 months, not getting a response. And the defendants both moved to dismiss because we hadn't exhausted our administrative grievances, and also moved to dismiss because we should have assumed it was denied, and therefore we shouldn't have waited so long to file. So it leaves prisoners in this, and lawyers trying to represent them, in this odd situation where they kind of have to guess whether or not they've waited long enough in order to file a case. So we always tell prisoners one way to try to avoid that problem is just write a lot of requests to your counselor, all those letters to your counselor, letter to the warden saying, hey, I filed this grievance, what's happening with it? Keep copies of those. If you ultimately get to court because they haven't ever answered it, then you can show the judge, hey, I tried best I can to get an answer to this thing. They never responded to me, and therefore I couldn't just sit there and waiting forever. I needed to file this lawsuit. So that's a good rule for all of this. Document, document, document. We strongly suggest that prisoners keep like a little diary or a calendar or something saying the day they handed the grievance in, how long they waited, whether they, each time they talk to their counselor or the grievance officer, whoever they talk to about what the status of the grievance is. You want to keep those records because if and when you get to court and you're fighting about whether or not you in fact exhausted your administrative remedies, the more evidence you have, the better off you are. Typically, this comes down to, and what I would say, 50% of the cases we get, the vast majority of cases we get, are a prisoner saying, I submitted a grievance and I never heard back, so I sued. The prison says, you never submitted a grievance. So the more records you have, the more proof you have. If you kept a copy, if you wrote the grievance officer saying, hey, what's happening to the grievance that I filed. All those things are pieces of paper and evidence that supports the fact that you did in fact file a grievance. So that's an awful lot of what happens. Grievances just disappear, either because somebody takes them out of the grievance box. There's supposed to be a grievance box on each unit where prisoners can put the grievance in the little box. And in theory, only people from the grievance office have the key to that box. But that's not what always happens. Or it just got lost and it's sitting in somebody's desk drawer somewhere and that never got processed. There are lots and lots of grievances filed, not enough grievance officers to deal with them all. So it's not surprising that some of them just disappear. It's, we've certainly heard that one way a grievance officer can, quote, catch up is just throw a bunch of grievances away and then all of a sudden they're caught up. And of course, he would deny that he threw things away and could just claim he never got them. And how is a prisoner supposed to prove otherwise? So those are the kinds of fights we have. Go ahead, Julie. What I want to do next is talk about the grievance process. And I know that some people watching probably have people who are in the county jail or in one of the county jails in the state or in the federal system. Each of those have slightly different grievance rules. And I urge prisoners or their loved ones to get a copy of those rules and familiarize yourself with them. But they all look very similar. And I know that I think the vast majority of people on here are likely to have people in the Illinois Department of Corrections. So I'm going to talk about that process rather than either Cook County Jail process or the federal process. So go ahead. There are lots of steps for most grievances, and things can get lost at each one, or prisoners can screw up at each one. So something happens that you want to complain about. Your first step is to file a grievance with your counselor. In theory, that is called an informal dispute resolution, but really you're filing the same piece of paper with the counselor that you're going to use to file your formal grievance. The counselor then responds to you and says, usually, I can't resolve this, or I tried, but I can't do anything about this, or you're wrong. And if you disagree with that, then you have to file with the grievance officer. The grievance officer is a correctional counselor who's designated as the grievance officer. It's usually not their full-time job. They have a bunch of other stuff to do. And there's always more than one in every prison. That way, if you file a grievance against the grievance officer, it goes to the other grievance officer. So nobody's ever ruling on a grievance against themselves. Note, some prisons have so many people that are related. It may not be the person you're filing a grievance against that's the grievance officer, but it might be their cousin, or it might be their daughter, or father or brother, who is the grievance officer. So you can imagine your chances of winning the grievances are pretty low. The grievance officer does not give the response back to the prisoner. Instead, the grievance officer makes a recommendation to the warden. In general, wardens do not actually look at grievances at all. Wardens designate somebody else, which is fine. It's okay in the law, who looks at grievances. As one warden testified in one of my cases, if I reviewed every grievance, that's all I would ever do. So they generally delegate that to somebody else. And frankly, there's usually not any review at all by the warden's office. I would say in 99% of the time, they just adopt whatever the counselor said. If you have a case where the warden disagreed with the grievance officer, then it's probably a very meritorious case. And those are the kinds of cases that I really jump on, because it means somebody agrees that some staff member somewhere probably screwed up. The warden's response does go back to the prisoner. The prisoner then has a time frame in which they have to file with the Administrative Review Board. That's a body in Springfield, which reviews all the grievance appeals. That body does not, again, give the response back to the prisoner. Instead, they make a recommendation. On paper, it goes to the director, but just like the warden, directors don't ever look at grievances. They designate other people. Almost always, that's another member of the Administrative Review Board who is making the second review, as it were. So one member of the Administrative Review Board recommends what the director should do. Another member of the Administrative Review Board agrees that that's what the director should do. And that's the end of the process. So if you make it through all of those 6 steps, then you have exhausted the administrative process and you can go to court. But if you miss any of those steps, then you can't, and you may never be able to sue again. Let's go one more. There are a couple of exceptions where you can jump a bunch of those and it's only a 3-step process. And those three exemptions are appeals from protective custody. So if a prisoner wants to go into protective custody and is denied, they don't have to go through the process at the prison at all. They can jump right to Springfield and say, hey, I belong in protective custody. They're not letting me there. And then the ARB gives that to the director, and it's the same process at the end. But you skip all those steps in between. The second is people who are involuntarily forced to take mental health drugs, psychotropic drugs. If you are being involuntarily drugged, then you absolutely, again, don't have to go through the whole process at the prison. You can jump right to Springfield and get that decision reviewed. Again, that's because that is such an invasive procedure to your body and to your mind that the state has recognized that that is something that should be dealt with right away, and you shouldn't have to go through that whole process. The final one, which is what comes up most, is things that aren't about property. So if you are complaining that a guard destroyed your radio, then you have to use the regular process. But if, for example, you're saying that you got beaten up by a guard, and often what happens is you get beaten up by a guard and you're immediately transferred somewhere else to a different prison. And if you're transferred, then again, you don't have to go through this process at either your new prison or the old prison. You can jump right to Springfield. Sometimes we've been able to take advantage of that because people have been transferred, like I just described. Other times you can take advantage of that is if they get moved, for example, to go to court on another case. So, for example, somebody gets remanded back to Cook County, they may be taken to the NRC from wherever they are. The minute they walk into NRC, they can file a grievance immediately with Springfield and skip all those steps in between, even if they're only there temporarily. All that matters is the day you file the grievance where you were. So if you're at a different prison and you're complaining about something that happened at your old prison, you can jump right to Springfield. You don't have to go through the whole process. And frankly, it can save you months and months and months. This whole process is slow. It can take over a year to go through the entire process. Even though each of those steps is supposed to take 60 days or less, it doesn't. As I said, there's a wiggle room in the statute, and believe me, they take advantage of this wiggle room. When we were getting ready to file our case about deaf and hard of hearing prisoners several years ago, it took us 18 months to with the help of like 6 lawyers, to get through the entire grievance process before we finally got a final ruling from the director. So you can imagine the frustration that people have when they're in prison, trying to get through that. And go to the next slide, and that'll talk about some of those deadlines. I believe that's the next one, yes. So prisoners have tight deadlines. You have to file with the counselor within 60 days, and what happens? The counselor doesn't have a time limit. The grievance officer is you're also supposed to file with the grievance officer with 60 days. But what do you do if you don't have a response from the counselor? Because you can't file the grievance officer unless you get a response from the counselor. If you do, they'll send it back saying, where's the response from the counselor? You jumped the gun. So it's odd because you have 2 60-day time limits, which have the exact same 60 days, but you have to accomplish 2 steps of that 60 days. As with many of these rules, the only purpose of them is to make sure the prisoners can screw them up, because if they do, then they're barred from bringing cases forever. Grievance officer then is supposed to have 60 days to respond. That's where reasonably feasible under the circumstances. In other words, unless they don't want to. Then you only have 30 days to appeal that decision from the warden within 30 days. If you miss that by a day, then you're out forever. There's some dispute as to whether or not the 30 days counts from the day you mail it or from the day the Administrative Review Board in Springfield receives it. The Department of Corrections takes the position that it has to be received by the Administrative Review Board within the 30 days. A prisoner, of course, has no control over that whatsoever. Once you put it in the institutional mail, you can't do a darn thing about speeding it up, and there's no other way to get it to Springfield other than through the institutional mail. So most, but not all courts have agreed that the 30 days counts from when you put it in the mailbox in the prison. After that, it's the Department of Corrections' fault as to how long it takes to get from Springfield, out of your control. So as long as you put it in the institutional mail within 30 days, you should be okay. Not a guarantee. Again, then that administrative review board makes a recommendation to the director, no time limit on that. But the director's decision is supposed to be made within 6 months after receipt, where reasonable, feasible under the circumstances. Again, meaning if they get backed up, too bad, there's nothing you can do about it. So that's the timeline we're working under. This is a good place to stop because we're about to go through what the grievance system actually looks like, the pieces of paper you file. So I don't know if there are questions or comments or anything like that. I'm happy to take any questions people have right now, if there are.
Does anybody have any questions?
I know I went through a whole lot really quickly, so I'm happy to circle back. But Julie told me I should finish quickly so people can ask a lot of questions at the end.
I'm just, yeah, just so one-sided. When you go through it like that, you're like, wow, okay.
And you can see why it means that so many prisoners are like, I'm not going to file a grievance because it's useless. It is a very one-sided issue.
Yeah, it's very one-sided. And I think one of the big questions we're going to get, which you can address probably later, is about good time and grievances. So, I mean, not probably right now, but that's, I think, a big question a lot of people have. I've been getting a lot of questions about good time, and I
Yeah.
know that a grievance needs to start with a grievance if they don't give it to you.
There's a question I just see about a grievance. Well, I missed it though. It went flashing by. Something about the warden.
Oh.
It says, what if you have a grievance about the warden? Is there any difference in the process?
There isn't. I mean, obviously, you're not going to win in front of the warden if it's about the warden, but you still have to go through that process. You still have to go to the go to your counselor and go to the grievance officer, and then then it goes to the warden. So obviously, neither the counselor nor the grievance officer have any power to say the warden was wrong because they work for the warden. But nonetheless, there is no such exception in the rules. So yeah, you have to walk through that process. It's only after the warden says, yeah, what I did was right, you finally have an ability to go to Springfield and get somebody, at least in theory, who can second guess the warden. A related question, which nobody did ask, but which I'll answer anyway, is what if your grievance is about an action by the director? So for example, if you are challenging a rule or an administrative directive or an institutional directive or a transfer decision, all of those things are considered to be decisions by the director, and you don't actually have to use the grievance system to challenge things that are by the director. So you can skip this whole process and go right to court if you're challenging something that the director, his or herself, did, or which is deemed done by the director. So for example, when we were challenging all of the decisions to transfer people to Tams Correctional Center, our Supermax prison, back when it existed, ultimately the ruling was we did not have to go through the system because it was deemed that the director made all the decisions about those transfers, and therefore there was nothing you could challenge. The whole point of the grievance system, again in theory, is that you are bringing to the director's attention somebody who is violating the director's policies. So yes, you can challenge a warden for disregarding the director's policies, but obviously you can't challenge the director for violating the director's policies because it's the director. Is the review board over the ARB and director? No, there is not. Many people have been asking the legislature to put in either a real independent oversight body or an ombudsman or some sort of independent organization that could act as an outside check of the Department of Corrections, but so far none of that has passed through the legislature. There have been several bills that have been introduced for that, but right now there is no external review of what the director does, other than the legislature, and really they can't get into the nitty-gritty. They control the budget, but not what happens on a day-to-day basis in the department, and frankly, they don't care enough My favorite example of that is a bill was introduced to give the legislators the right, not the obligation, but the right to go into a prison to inspect them. And the legislators refused to give themselves even the permission to do that. So obviously they're not going to come in and say, interfere with the actual operation of the prison. Again, the governor obviously does have the power to do whatever he wants with the prisons. He can fire the director, he can direct the director to do whatever he wants. But as I'm sure we've all seen, most governors, in fact, all of the governors, have considered to be the Department of Corrections really as the third rail. They don't want to get involved because they're afraid that somebody will do something that will make the press and make them look bad, and they'll be labeled as soft on crime.
Alan, there's another question. What about a family filing a grievance?
The rules say that the grievances should be filed by the prisoner. So mostly those will be turned down. Now you can write the grievance and send it to the prisoner, but the prisoner has to send it through that process. We have fought that out as to whether or not a lawyer for a prisoner has the right to file a grievance on their behalf, and there's been some mixed results on that. But I've never seen a court say it's okay for a family member to file a grievance. Yeah, so generally I think a prisoner has to do it on their own. That's the way the rules are written. Again, it's just a way to make it difficult. None of this makes any sense.
So Alan, you were saying that some people was voted not to go inside the prisons because wouldn't they have to give notice, just like when they do audits, they give the audit people a 3-day or a 3-week notice before they even come into the side of the prison?
Yeah, I mean, the way you're talking about whether or not the legislators would have the right to come in.
Yeah.
I mean, that's not the way the bill was written. The bill gave the legislators the same right to go in as the governor does. Right now, the governor has the right to go into any prison at any time, either without notice, if he wants to. All the bill did was say the governor and the legislators have the right to do that. So if it had passed, which it did not, then they would have had the same rights to go into the prisons as the governor did.
Without
they
notice.
could have walked in with no notice whatsoever.
Okay.
That would have been a great thing. But now, as of now, the Department of Corrections absolutely can keep out any legislature they want to, and they can pick and choose who they're going to let in. And as you can imagine, they give guided tours to those legislators that are friendly, and they delay forever those that are not so friendly.
Alan, one more question. If the grievance is about needing medical care, but they wait too long and there's a permanent defect, when does the time clock start? At the time of the problem or at the time of knowing that the problem is permanent?
That's an excellent question for which there is currently pending some cases. I think the best answer, and I think the one that's going to ultimately prevail, is that as long as you're under the care of the doctors who are screwing up, meaning Wexford, then it's okay to file it at the end of the process. When you finally figure out what's going on, or you finally figure out that it's permanent. The theory is that it's a continuing, what they call a continuing tort. That is, every day they deny you medical care is a brand new action, and therefore, as long as they're denying you care, it's still time, 60 days after the last time they deny you care to file. I won't say the department always agrees with it. We just are dealing with a case right now where somebody was mistreated for several years and didn't file a grievance until some doctor finally properly diagnosed him and said they'd been screwing up for many years. He filed a grievance then, and the Department of Corrections said, too bad, you should have filed way back when they first denied you the right care. Like, as I say, it's being litigated right now. I think that the department has the wrong side of that, but I don't get to wear the black robes. I just litigate. So I can't guarantee that that's going to be the answer.
I will say, Alan, we have a few people, someone who said she was formerly incarcerated, and she said they don't take grievances seriously. And
yeah, I mean, there's no question. Lots of grievances get thrown away. You can file in theory a grievance about anything, But as to whether or not it's actually going to get read is a whole different question. So yeah, I'm completely with those people who have been formerly incarcerated who know better than I what it means. Good question. Have there been any successes? Yes. We've gotten several out of several thousand. We've gotten several grievances where either the warden or the administrative review board has said, yes, in fact, somebody did something wrong. And I've got a great example of that in a minute to show you just how frustrating this process can be. Let me move on. I think, unless
Yeah,
there's
let's
something else.
move on, and we'll
Okay.
address those in a few minutes.
Yep, there'll always be more. All right, so as I started off saying, you have to use the right forms. So there are lots of ways that prisoners can bring things to the attention of authorities. You can write resident requests, you can talk to your counselor, you can talk to a guard, you can talk to the warden as he's walking by the cell, you can send a letter to somebody. None of that counts. Even if you get, like on the right-hand side here, you have a nice formal memo from the senior chaplain denying my client, Brian Nelson's request for a religious diet. It's clearly a formal ruling on this, but he didn't file a grievance. He only filed a resident request. And therefore, even though you got a nice formal response from the person who's in charge, it didn't count as exhaustion of his administrative remedies because he didn't fill out the right form to start it with. He filled out the resident request form instead of a grievance form. So it doesn't count. Next slide. This is what a grievance form looks like. It's got several parts. The prisoner fills out at the top his name, etc. And then there's a portion at those check boxes kind of indicating what kind of grievance it is. But the most important part then is the summary. And even though it says it's a brief summary of the grievance is what it tells you to do, the rules in fact say you have to be very specific. Like I said at the beginning, you should be identifying who it is who did something wrong. And if you don't know their name, identify what they look like or their shift or their star number or what position they held in the prison. In the maximum security prisons, these are all handwritten because they ban typewriters. And some of the mediums and minimums, people can type them and make them a little more legible. But we get a lot of copies of grievances and we spend a lot of time trying to decipher everybody's handwriting. So that's what the first part of the grievance says. Go to the next part, next page, or next slide. This is the counselor's response. And generally what the counselor will do is call up the person who is responsible and say, hey, this person filed a grievance against you. Are they right? And typically the person that you're complaining about is going to say, no, they're completely wrong. And that's exactly what happened here. Mr. Nelson complained about not getting his diet. The chaplain writes back and says, I already answered Mr. Nelson and explained why he is not entitled to a religious diet. Interestingly enough, he says because Brian's version of the Catholic faith is wrong. And he went on to quote a whole bunch of sections of the Bible that he, being a Lutheran, says is actually the right kind of penance to do, not what the Catholics say, but what the Lutherans say, and therefore made his official designations to what a proper penance is, which didn't involve not eating meat in his estimation. So that was the counselor's response. Go on to the next slide. It then goes to the grievance officer. And again, the grievance officer is reviewing what the counselor said and making their own independent determination. And again, all that the grievance officer really did here is to quote the chaplain as to what a proper biblical penance is. As you can see, kind of blurry here, but he's talking about Jesus or God's word and what they have ordered in terms of what a good penance is, which I found absolutely incredible, given this whole idea that we're supposed to have a separation of church and state. But here we have a government official telling Mr. Nelson what the Bible says about what a proper penance is. So the grievance officer is making this recommendation then to the warden, and I think the next slide should help us go to the next step. Yes. And here you have the warden just checking a box saying, I concur. As you can see, the warden has three choices. I concur, I do not occur, or I send it back, meaning remand, saying remand, which means send it back to the counselor or the grievance officer to look at this again. I think this one's for you, Julie. Can you put a copy of the blank grievance form on your website somewhere? I leave that to you all.
I think we could probably do that. Yes.
I don't remember. We may have one on our website, the Uptown People's Law Center website. I know we have a resources page. If it's not there, that's a good thing we should add. Good suggestion. Thank you.
Yes.
Okay, now just to show you how frustrating this can be, I want to use a different grievance. So go to the next page. Oh, I'm sorry. That's a fine. This is what the final ruling looks like. So this is what you're looking for when you finally get to the end of it. You're going to get a ruling from the Administrative Review Board, and this is the form they use. This is an example of how that form can be really confusing. This is somebody who was challenging a disciplinary report. And you can see that the Administrative Review Board checked 3 different boxes. First, they say it's denied because it was appropriately addressed by the facility. Second, they say it was denied because the facility followed the rules. And third, they say the disciplinary report is expunged anyway. So did he win or did he lose? He did both. They denied the grievance, but he got what he wanted, which was to have this disciplinary report expunged. Why they did that, it doesn't say. It gives you no hint. So this is a perfect example of how you can get a response back which makes no sense whatsoever, and you frankly have no idea what they did. Is the grievance, is the discipline still there or not? It doesn't say that he's going to be given his assignment back, which is part of the discipline he got, was removal from his assignment. If the report was expunged, then why shouldn't he get his job back? But it doesn't say that, and he didn't in fact get his job back. So the disciplinary report is still in his file. They didn't actually remove it, and he didn't get his job back, but he still won, saying it was expunged. But also that the Centralia did it right by not expunging it. So you go through this whole process, you waited 6 months, and you get an answer finally, and like, what the heck does this mean? I have no idea. Go to the next slide. Which is why people are so frustrated by this system. It is unbelievable how difficult the system is and why prisoners get frustrated. I get frustrated as a lawyer, and I'm not sitting there in a cell trying to figure out what the heck I'm supposed to do. Go on to the next one, just to show you some more examples of frustration. So this is a man who wrote a grievance about a shakedown. Happens all the time. You get shook down, they destroy some of your stuff. Even though they're supposed to be searching it, they in fact destroy it along the way. So I filed a grievance saying I want to be compensated for the stuff they destroyed. And go to the next slide. Oh, yeah, sorry. There's go back to that. So one of the things the department started doing is giving prisoners a receipt with a tracking number on it. For many, many years, they didn't do this, and therefore it was entirely the prisoner's word as to whether or not they handed it in or not. Now, when you get a receipt back with a tracking number, you can prove you at least did the first step. Now he can say, I got a receipt back saying on February 24th of looks like 2016, whatever that says, I got a receipt saying my grievance was number 628. Therefore, obviously I filed it because now I know I have receipt 628. It took 3 different decisions from the 7th Circuit Court of Appeals telling the Department of Corrections that they should at least have a receipt system before they actually had a receipt system, which seems to me the simplest thing in the world. Anytime you go to a store and pay for anything, you get a receipt. Anytime you return a library book, you can get a receipt saying you got the library book back so they can't claim you have it anymore. For some reason, the Department of Corrections, even though it meant whether or not you could go to federal court or not, couldn't give receipts. Now they do. So that's a small step forward after lots of litigation, including 2 cases by us. Next slide. So somebody asked whether or not anybody ever wins a grievance. Well, in this case, the counselor says, I was there. I saw the TAC team take his stuff. He should get the value of it back. So the counselor was there. He's a witness for it. He says, yes, I saw him do it. He should get his money. Next slide. It goes to the grievance officer who quotes that saying, yes, I was there and he should get review. But what does the grievance officer actually find? Next slide. Says there's no evidence. How can there be no evidence? They just cited the counselor saying he was there. That's the evidence to support it. But nonetheless, the grievance officer says, sorry, there's no evidence. We're going to disregard what you said. We're going to disregard what our own staff says happened. We're going to deny it because, quote, there is no evidence. What better evidence could there be than the counselor themselves saying, yeah, I was there. I watched the department, I watched the correctional officers destroy his stuff. He should be compensated. Sounds like evidence to me, but no, it doesn't count. So you can see why prisoners get so frustrated, and it's hard to convince prisoners that they should always file grievances. But that's what I want you to take away from this presentation more than anything else, is it doesn't matter how hopeless it is. It doesn't matter how bad the system is. It doesn't matter that you're always going to lose grievances. You have to go through this process. Otherwise, people like me can never take your case to court. Now, I don't say prisoners should always file grievances, because you can be, there are some costs sometimes to filing grievances. It has certainly been known that if you file a grievance against an officer, they'll go around the unit saying you're a snitch. Are you a snitch against other prisoners? No, you're a snitch against the guard, but you're still a snitch. And, you know, that carries some danger in prison to be labeled as a snitch. And guards absolutely can use that against you, or they can retaliate against you in other ways. You know, skip your meal the next day, or not take you to the yard your next time, or when your family comes to visit, pass down the word, say no, they refuse the visit. And your family is driven all the way to Menard, and the guard comes out and says they refuse to see you today. What are you supposed to do? There's nothing you can get around it. So there are lots and lots of ways that guards can retaliate against you if you file grievances against them. It's illegal, but that doesn't mean it doesn't happen. So I am not going to sit here and tell a prisoner that they should always file a grievance about everything. But if they ever want to bring something to federal court, they have to go through that process, even if it's totally useless, even if they might get retaliated against. Prisoners ask me, can you protect me if I'm retaliated against? And the answer is probably not. Retaliation is really hard to prove because they usually don't do it themselves. They have somebody else do it. If you file a grievance against guard A, it's not going to be guard A who retaliates against you. It's going to be guard Z. And how are you going to prove that guard Z even knew about the grievance you filed against guard A? They, I'm sure, talk, but proving that is a whole different ballgame. So I can't sit here and tell a prisoner that they have to take that risk of filing a grievance, because I realize it's a real risk. But I can sit here and emphasize to everybody's a loved one, everybody's incarcerated, that if you don't file a grievance, you're never going to go to federal court. Don't bother to write me saying I can help you out if you haven't filed that grievance, because I can't. That'll be the first thing we ask anybody is, did you file the grievance system? Did you at least try to get all the way through? If you didn't, I don't care how good your case is. I don't know how badly you're injured. I don't care if you've got 100 witnesses. I don't care if the warden himself will testify in your favor that you were wronged. You're going to get thrown out before you get to that point, which again is why there's such an incentive here for the Department of Corrections to run a bad grievance system. Because if people don't file, then it's way easier to defend saying people didn't file the grievance than it is to defend what they actually did. And I think that was the end of my slides. The next slide just shows you how to get a hold of me if you want to find out more about the Uptown People's Law Center. Yep. So I'm going to stop talking for a minute and let other people talk or ask questions or make comments or whatever there is in the chat there. I see we got 30 chats, so that's a lot.
So there were a couple other questions in the chat that I don't think got answered earlier. One is about a hunger strike and what the rules are about seeing a doctor when someone's on a hunger strike.
Okay, not a question about grievances, but I'll answer it anyway.
Well, I think maybe the question is about how do you know when to file a grievance related to that?
As I said, I'm happy to answer it anyway.
Yeah.
Whether you can squeeze it into the grievance process or not, I don't care. The department's policy is, I think it's after 3 days on a hunger strike, then you're supposed to move to the healthcare unit. In the healthcare unit, you should be seen by a doctor. However, it's 3 days from when you formally declare a hunger strike. And often people just stop eating and they don't count that as declaring a hunger strike. You actually have to tell somebody, I am going on a hunger strike. And if you do that, then they come into your cell, they generally search it, remove any food items you may have in there. If they watch your commissary account, if you buy anything off commissary, then you deem not to be on a hunger strike anymore. They'll also watch to see whether or not one of your neighbors passes you something to eat. If they do that, then your hunger strike is over. And they can claim all that happened, even if it really did. So I'm not going to sit here and tell you that everybody who goes on hunger strike gets sent to the infirmary after 3 days, because they don't. But that is in theory what's supposed to happen. After a certain period of time, it goes one step further. If a doctor says that your health is in jeopardy, then the warden has the power to force feed you. Generally, that happens somewhere around 30 days, but that's very dependent on exactly how the health of the person is, the willingness of the warden to step in, what the doctor in the facility says. So there are lots of things that can happen during that time period that may or may not lead to force feeding. Sometimes they'll just let you sit there and get really, really badly off. Of course, force feeding is a huge violation of your bodily integrity. It's not a pleasant thing to go through. And you know, they changed the law on that, giving the wardens this power. They used to have to go to court to get a court order to force feed. We defended a couple of those cases and won, after which they changed the law saying they don't have to go to court anymore. The warden can authorize it, him or herself. I think that answered that question.
Okay, great. And then there's another one. This is more of a comment, but I wonder if you have something to add to this. Someone wrote, there's something they're doing where several people are writing and signing the same grievance, and they're saying they won't accept those kind of grievances.
Not only won't they accept them, they in the past have charged people with unauthorized organizational activity for doing that. In fact, one of the very first cases I did in the Department of Corrections back in like 1980 was a case where a clerk in the law library, a prisoner law clerk in the law library, was helping prisoners write grievances about how bad the food was at the old Joliet prison. And he wrote essentially the same grievance for 20 different people, all of whom filed that grievance. And they charged the clerk with unauthorized organizational activity because he was allegedly gathering these people together, even though he's just doing the job he was assigned of writing grievances. A related question is whether or not you can include more than one complaint in your grievance. And even though there's no rule saying you can't do that, they often will only answer one of the first item that you raise in a grievance. So you may say, I got beat up, I went to the doctor, they refused to do anything about it, I went back to the doctor and they didn't do anything again, and now I have broken arm, whereas it could have been fixed within 30 seconds of it, it's dealt with right away. Often the grievance officer will talk about the first thing, that is, I got beat up by a guard, ignore all the others. And the question then is whether or not you have appropriately exhausted your administrative remedies. There's no rule that says you can't put more than one thing in the grievance, but you're likely to only get ruled on one of them.
So,
Okay.
Alan, I'm sorry.
Oh, hang on. If you don't mind just like posting in the chat that you have a question you'd like to ask. I'm trying to go through them sort of in order, and I can call on you when it when it gets to your turn.
Okay, I'm trying to find chat. Go ahead.
Unless, was that Ronnie? I'm not sure who unmuted, because Ronnie had posted, if I'm saying that right, had posted that they have a question.
Yes, I do.
Okay.
Thank you for acknowledging my question. And Alan, you may not remember, but I'm a piggyback off of this starvation issue, because my son, and I know you know him, Chaz Thrill-Hill.
Yeah.
So in 2020, during COVID, he went on a starvation during Black History Month, and he starved himself for 28 days. Toward the end of February, he did go to the infirmary. Senator Peters was involved. You were involved. There was a total review of Menard Prison. And when they threatened, and they didn't have a doctor on the premises at all,
Right.
in an unsanitary environment, when they said they was going to put a feeding tube in his stomach, I directly contacted Pritzker. And I begged, the counselor took her cell phone in the infirmary and made Chaz take a bite of bread, and that ended it. And I can't make this up.
You know, I wish that were unusual, but I think you know, going to those extremes are exactly where many things happen.
Yes.
In many cases, actually, and you know, the odd thing is when people are in that sort of situation, I think one of the most helpful things can often be a call with a family member. And unfortunately, when you're hunger strike, the one thing they do is deny you those calls. They often deny you visits as well, even though sometimes talking to a family member is actually what the prisoner needs in order to say, hey, you know, you really should be eating. There's other ways to fight this, rather than putting your health at risk and certainly getting a tube shoved down your throat.
Absolutely.
I think it's a huge mistake that they cut off communication with family members when you're on hunger strike. They should, in my opinion, not that I run the department by any means, but they should be increasing the communication with family members. Because I know of almost no mother who would say, yeah, you should starve yourself to death in prison.
Absolutely. Not to cut you off, Alan, but and I have something else to say. That was done during COVID because the IDOC was not giving the inmates soap, food. They were rationing out just minimum amounts of food. And then there was the water condition at Stateville. It was horrible. And it piggybacked on Menard, which is one of the, I believe, oldest or second oldest prisons, or is the oldest prisons within Illinois. Yeah, absolutely. The flooding and everything. So Chaz was like, I'm not taking it no more. And he stood up as a Marine, as he should, and fought for that. So my question to you, and I'm not taking up too much time. Chaz was at Dixon Prison, and he was ticketed for being an escapee. He was not trying to escape. He was on an appeal for his current charge, and he was going back and forth to court monthly. He was just in the wrong place at the wrong time during a count. And they charged him with being an escapee.
Yep.
So when you get that charge, the maximum amount of time is 5 years. It's in the regulations on their website. Chaz has been on level E for 7 years. He transferred from Dixon to Menard, and now he's at Lawrence. He has filed grievances. I'm getting those grievances notifications because his wife Brandy is on this video as well, and that we have been talking to the contingent department. We have talked to the warden, the lieutenant at Lawrence's. They're understaffed, and every month for 2 years, they have denied, this is from the director, denied him reclassification.
Right.
Exactly. And it's 7 years. It's beyond, it's overkill. And it's messing with him mentally. I don't know what else to do.
Yeah, I mean, the problem is that the courts have ruled that the courts have no say in whether or not somebody is classified as a escape risk. They say that's purely a security issue. There's no right to be at any particular level unless they're doing it in retaliation for exercising a First Amendment right. But they can be arbitrary about it, and they are. You know, and even, I don't want to say it's even worse because it's just as equally bad. Somebody back in the day when Tams was open had a map of China, which he got from National Geographic, and they charged him with an escape attempt for that because they said they could use the map in order to figure out how to get around China. Should he make it there? You know, I don't know. But that was their allegation, that because he had a map of China, he was clearly trying to escape. and got listed as level E for several years because of having the map that came in his National Geographic, which they should have taken out, but the mailroom didn't. And therefore he was charged with an escape attempt for having it.
But we're going on 8 years, Alan.
I get
Come
it.
on.
I get it.
What
I'm
if
not saying,
what
I'm
if
not
I
saying
didn't?
it's rational. I'm just saying there is not really a legal way to challenge that.
I think we have a few more questions too. I'm sorry.
Yeah.
Okay, I'm sorry. I'm
So
sorry.
there's another question. John is asking about whether a denial on earned discretionary sentencing credit is a grievance issue, and whether there's a way to find out why, if it was denied and why.
Okay, so I talked earlier about how there are a couple other class action lawsuits on the way, and that's one of them. So we are actively working on some litigation about the department's failure to follow the new law on awarding good time. And our position is it is not a grievable issue because it is about whether or not you're going to be released from prison. And that's not a prison condition, and it's something that the director has decided what those rules should be, and therefore it's not a grievable issue. But we haven't filed our case yet, so I don't know whether or not the department's going to agree with us that it's not a grievable issue. Again, my advice to everybody is file the grievance. If it's not a grievable issue, they'll deny it as not grievable. If it is a grievable issue, then you go through the process when you've grieved it all. So I don't know the answer to that question. I have my position on that question, but it has not been litigated yet. So I want to be very clear that I'm only telling you what me as an advocate is arguing, not that I'm going to win.
So people should file grievances on their
Yes,
earned just as a starter, right?
it can't hurt is my argument.
Yeah, okay.
And it
Good.
may save the day. So
Yeah, okay. That's okay. That's a good one.
but stay tuned. Within the next couple of weeks, we expect to have something on file.
That's exciting.
Okay, next question. Are there any key do's or don'ts to help your counselor or grievance officer take a grievance more seriously?
I mean, obviously, the more details you can have, the better off you are. But I think the bottom line there is probably no. The vast majority of grievances are going to be denied by the counselor and the grievance officer and the warden, regardless of how meritorious they are. The department actually has training and manuals on how they should deny grievances. Regardless of whether they're right or not, and strongly suggest that grievance officers' jobs is not to expose their fellow colleagues through the grievance process. So, you know, I won't say it's the official department policy to deny grievances because it clearly is not. They will never say that. But I think that it's fair to say that the practice is strongly in favor of denying grievances. And of course, if you grant the grievance, then you don't have to appeal. So you don't have to go through the whole process. If you win, you can go right to court. So again, there's an incentive for the department to deny them so that you do have to go through a whole appellate process. Sorry to be so negative, but I don't want to lie to people.
Yeah. So I think that the answer to this is no, but there's someone who arrived late who said, did you talk about how the IDOC will take 6 months if you, it says if you didn't the grievance. I don't know if that means if you didn't win the grievance.
Right. I'm saying that at a time they would take 6 months away from you for filing a grievance if you didn't win that grievance. And I don't know if you talked about that, Alan.
I did not. So you're right. There is a law which says that if you file a frivolous grievance or a frivolous lawsuit, it's considered, I forget the words they use, but something like an abusive process. And you can, in fact, be you can lose good time or you can be sent to segregation for that. It isn't usually done, but lots of people lose grievances and don't lose any good time. But it is a threat that hangs out there. It's yet another way of discouraging people from filing grievances.
Okay, next question. Is there a limit on the number of grievances you can submit within a specific time period?
No, except that if you file a lot of them, you'll get a reputation as being a pain in the ass. And as I said, they can really do lots of stuff. And frankly, if you file too many grievances, then you're much more likely to trigger somebody saying you're abusing the process and therefore we're going to take good time or segregation. So I think every prisoner understands you have to pick your fights in the prison system. You know, people probably have 5 or 6 things a day that they could file grievances about because nobody follows all the rules in prison at all. You could theoretically file a grievance about every one of those, but nobody does. So you pick your fights.
Okay, I think Stephanie, that I don't know if that just answered she said, what if they were about 4 different things? And I think to your earlier point, you would want to file separate grievances, but
Yes,
pick your battles carefully.
both. I would say both of those things, right?
Yeah. Yes.
And I realize there's a contradiction there.
Yeah.
Yeah.
Okay, I think that is all the questions that have been posted in the chat thus far. Anything else?
Yeah, it's kind of disappointing, the process.
I do want to be clear. I mean, somebody put in a chat the link to our webpage, which has a nice handout which is what we send to as many prisoners as we can, saying how the grievance process works and what they have to do. It is not a copy of the blank grievance form. So
yeah, I noted that. I was one
there.
who put that there. I noted that, but
Okay.
we'll work on trying to get that.
As will we. So whoever asked that, thank you very much for that suggestion.
Yeah. So then now here's a very good question from Alexis. Is there any tracking of grievances? And is there any power in a large number of people filing on the same thing?
The answer to the first one is not formally, but the answer to the second one is absolutely. If a lot of people file grievance about the same thing, then it will catch somebody's attention, probably the wardens or somebody working for the warden who would then report it to them. So, you know, I think there's always power in numbers. The department ought to have a nice computer system where they can identify, you know, if 5 different people in Menard say I got beaten up at just outside the visiting room where there aren't any cameras, then the department would know about it and they could install a camera there. But they don't do that. On the other hand, if 15 people all file grievance against one officer at more or less the same time, then somebody's like to notice and might do something about it. So I would say there is actual power in numbers, but there isn't a formal system where the department tracks those.
Got a few.
Okay, so follow-up questions. If there were 3 things you could change about the grievance process, what would they be?
I love that. You never know. There might be legislation down the road for this.
Well, I think the first and most powerful thing would be to have somebody outside the department have copies of all the grievances that are filed, have its own tracking system, and therefore an outside oversight agency can use the grievances then to identify problems and fix them. That would be what matters. If you're not going to do that, then the department ought to be tracking them themselves through a computer like everybody else in the world uses. And I have to say, Illinois is among the very few states that don't have some sort of computerized tracking of grievances so they can keep track of what's going on. And they need to be, and the third thing I would say is they should be used by the administration to identify and solve problems rather than just as a way to argue that people should be thrown out of court, which is frankly the only purpose of the grievance system right now.
That's interesting. Yeah, especially the tracking of the grievances.
Yep.
I can't believe it. Well,
the Chicago Police Department does it. So can the Department of Corrections. They just don't want to. They don't want to know where the problems are. And you know, part of the problem is if you know what a problem is, you have you're likely to have a constitutional obligation to fix it. If you don't know, then can't violate the Constitution. So the courts have created an incentive for prison officials not to know what's wrong in their own prisons.
Yeah. Yeah, it's at the very least, they should be tracked. They don't track family complaints either, though, and
Again, without an outside agency, I just don't think it's going to happen because there's so many incentives not to do it for the department.
Yeah, and I'll just say for everyone to just be a real Debbie Downer that typically when we try to get legislation passed like this, that has to do with accountability within the Illinois Department of Corrections, the legislators look to them to agree to it. So in other words, are you going to agree for us to discipline and look at you? And typically the department doesn't really want you to do that. So it might sound really like a normal, like, hey, this makes sense type of thing. But there's a lot of roadblocks. That's not to say people shouldn't try and still complain and call their legislators every single second that they can.
And there was, I know, from reviewing our newsletter, which is about to be mailed out, that there was a bill to create an ombudsman's office for IDOC that did not move at all.
There were two, one by Representative Slaughter and one by Rita Mayfield.
Yeah.
As I said, they wouldn't even pass the law saying that they had the right to go into prisons. So it's a pretty low bar.
Oh, I can't thank you enough, Alan, really. Does anyone else have any questions, or can I let you guys have your evening back? I so appreciate everyone signing in. And again, the recording will be available on Uptown People's Law Center website and also on ours. And I believe if you registered for this, I'll just look at Lizzie. Are we emailing it out?
Yes, we are. You'll get an email tomorrow with the link to watch the recording. And I just put in the chat the link to register for next month's training, which I'll let Julie, you and Alan talk about. Alan will be joining us again.
Yes, we're so lucky.
I guess I passed the test, so I get to come back again. Cool.
Oh my gosh. And I just love when you come. I don't have the date in front of me. I think it's September 18th at 6 o'clock. Is that right? Did I get it right?
Yeah, you got it right.
Yep.
September 18th at 6 o'clock. And we're going to talk, Alan is going to talk about medical issues. And if the grievance process made your head blow up, the medical issues it's so egregious that and I know so many people, Ronnie, you mentioned things about your son just tonight and about some of the battles with that. And sadly, we don't always have answers, but knowledge, just even starting and getting some knowledge is what everyone, the more we can spread it, the better. Alan, do you want to add?
Absolutely.
Yeah, I mean, I think, I think you're absolutely right. I wish I had a magic bullet saying, hey, if you do X, Y, and Z, then your loved one inside will get good medical care. I don't have that magic wand. So the kinds of things I want to talk about are what the legal standards are, the kinds of cases we can and can't bring, the failings in the system, of which there are many. So I want to get beyond I can tell you some horror stories and will, but I want to get beyond that and talk about some of the larger picture things. And then again, talk about some of the solutions that might make it better. Answering the question was asked today, if I could change 3 things about the medical system. I have a longer list than 3, but I'll work on trying to get it down to 3 in the next month before our next event together.
Yeah, I have a few too.
I'm sure we all do, and I do warn people that, I mean, if everybody in the audience were to just tell their horror stories, we would be there all night. So, I don't think we can use it as a forum for everybody to complain about how bad the system is, because it's horrible.
Yes. Well, thank you, everyone. And thank you, Alan. So
You're very welcome.